crying hysterically, mentioning that she was still in fear for her life.
Now, I know you talked about where Mr. Pierre said he was from and things of that nature. Did you ask those similar questions to
I did.
her?
To her, she mentioned that, if I recall correctly, she mentioned that he was from Haiti.
What about where she was from?
She was from New Jersey, which is where they met, she told me.
Did she indicate if she had, I know you mentioned she was staying with a friend, did she indicate if she had any other family or friends in the area?
No, the friend that she was staying with, apparently they had rented a room from when they had first moved here from New Jersey while they got their feet, they got on their feet. So they were stayed there for about a year.
Now, I know you mentioned you ended up putting up some crime scene tape to preserve some suspected blood, correct?
Yes.
I believe you indicated before that there, aside from the potential scratches that were in the photographs, there were no injuries on the alleged victim?
Correct.
No further questions, Judge.
Thank you. Any redirect?
No redirect, Your Honor.
Thank you, sir. You may sit down.
Thank you, sir.
Any additional evidence or testimony, state?
Your Honor, I would just ask that the court take judicial notice of the charging affidavit. I do have a copy of the score sheet. I have provided it to Ms. Smith, and then just argument.
Ms. Smith, any evidence or testimony?
No, Judge. Just argument.
Argument, state.
Yes, Your Honor. The state would argue that pursuant to, as we've already discussed, 907.041, subsection 4, and then subsection, I believe it's C5, the defendant meets the criteria for pretrial detention. Before Your Honor, the defendant is charged with 3 crimes that qualify as dangerous crimes: the kidnapping, the aggravated assault, and the aggravated battery with a deadly weapon. The state does agree he is entitled to bond on the grand theft auto. Your Honor, it is the state's position that based on the defendant's actions on March 4th.
A little bit slower, please.
Sorry, Madam Interpreter.
Thank you.
That the defendant is a danger to the community and especially to the victim in this case, Your Honor. Based on all of the facts and evidence that has come out during the hearing today, it is made clear first that the defendant and victim had been in an argument, and the defendant was actually in the process of moving back to New Jersey when this incident occurred, and he essentially lured the victim back to their shared apartment to get some belongings. The victim, as stated in her sworn statement and through the officer, did not feel comfortable going upstairs with the defendant. However, he proceeded to go upstairs and retrieve a butcher knife that he then concealed in a sweatshirt. This was in broad daylight at about 8 a.m. The defendant, although did not yell and scream at the victim, he instead was very silently aggressive, holding the knife to her back, to her leg, forcing her up the stairs. He was determined to get her into that apartment at all costs. She believes truly that he was going to kill her on that day, and she does write that and tell that to law enforcement numerous times, that if her neighbor, who she did not know, did not step in, that she wouldn't be here today. Now, without Mr. Dykes standing in, we may be having a very different conversation, but luckily when Mr. Dykes did retrieve his firearm, the defendant did eventually drop the knife, but we do have Mr. Dykes who saw exactly what was going on. He saw the defendant with the knife pressed against her back, put her into a chokehold, and then proceed to, upon seeing the firearm, pull the knife up and eventually drop the knife before proceeding to harm Mr. Dykes or the victim at that point. Your Honor, the state is also concerned with the fact, if the court is inclined to give bond in this case, that the defendant is not local to Central Florida. He is not local to the state of Florida, period. At the time he was moving back to New Jersey, he has a Haitian passport and is on a green card. So the state is extremely concerned with his potential to be a flight risk in this case. I do note from the score sheet, he does not have any other significant criminal history outside of a reckless driving that was originally a DUI. I do not have access to any criminal history from Haiti specifically, and I'm not sure at what point he moved from Haiti to Florida, but it is the state's position that he does pose an extreme risk to the victim, specifically in this case being a member of the community, and the state would ask that the court hold him on pretrial detention in this case.
Very well.
Stand according to Judge, so I'll bring your mic. Judge, pursuant to Rule 3.132 sub C1, as the state indicated, the court can admit relevant evidence and testimony without complying with the rules of evidence. However, a final order of pretrial detention shall not be based exclusively on hearsay statements. While the state has introduced the statement of the alleged victim as well as her testimony through law enforcement, without her live testimony, that would essentially be hearsay as to prior acts of supposed violence that weren't reported, and information in terms of the incident in this case, aside from what Mr. Dykes testified to. In a motion for pretrial detention, the burden is on the state. Mr. Pierre has only been arrested at this point, has not actually been charged, which I know the pretrial detention can apply to both arrest and to charging, but in this case, he has not actually been charged with any crime at this point. So the defense would be arguing against pretrial detention and asking for a reasonable bond in this case with such conditions that can secure the safety of the community, such as no contact, no return, and things of that nature. Based off the facts and information alleged, there's no testimony that shows that there's no condition that would not secure the safety of the community or the alleged victim in this case. And we would ask that a reasonable bond be set in this case with such conditions as to no contact, no return, and other things of that nature, Judge.
Mr. Pierre Lewis apparently has no prior criminal history other than a reckless driving, which was deduced from the DUI. He's got no ties to this community, although those are really issues relating more to the amount of bond if it's stepped. The court finds that there's certainly a substantial probability that the defendant is guilty of the offenses for which he's been arrested. He, of course, is presumed innocent, but the state has heard the testimony and found the testimony of both witnesses to be very credible. The alleged facts are particularly concerning to the court. The defendant allegedly was in the process of a breakup with his girlfriend and went to the apartment to retrieve personal possessions, and for reasons that be known only to him, was apparently forcing the girlfriend back up to the apartment with using a butcher knife as a weapon. Based on those facts and the alleged prior incidents of domestic violence, the court does find that there's aren't any real conditions of release